What are the 5 biggest mistakes you must avoid if you're thinking about filing for bankruptcy? I'm Jonathan Ginsberg. I'm an Atlanta area personal bankruptcy attorney representing clients in the Atlanta area for well over 25 years. And I want to talk to you today about the 5 biggest mistakes I've seen over those about 30 years of bankruptcy practice that can really mess up your opportunity to file bankruptcy or to make it a lot more difficult or more expensive to file. So in no particular order, the 5 mistakes that you need to avoid when you file for bankruptcy or and you're preparing for filing for bankruptcy. And by the way, that's why, and you'll hear this from me over and over and over in all my videos, talk to a bankruptcy lawyer sooner rather than later. Don't wait until the last minute. Don't wait until you've made a decision, taken one of these actions that you think makes sense but could have really serious repercussions in bankruptcy. Talk to an attorney. I hope it's me, obviously, my firm, but if not, talk to a bankruptcy attorney sooner rather than later if you sense that bankruptcy may be coming down the pike. So let's go to the 5 biggest mistakes that you need to avoid when you're filing for bankruptcy. Number 1 is transferring property out of your name into someone else's name. And this can be filing a quitclaim deed. You can get quitclaim deeds, online, for that matter, and transferring your house or a piece of property to somebody else's name, changing the title to your vehicle, moving money out of your bank account and giving it to somebody else, selling personal property, furniture, vehicles, whatever, electronics to your brother or your neighbor for $1. Basically, the problem with that is that's called a fraudulent transfer. If you give something away or you transfer it for less than true value to somebody else, the bankruptcy court calls that a fraudulent transfer. And if they find that you've given stuff away, you've done that, even if it's not a whole lot of dollar value to it, that can be enough for the bankruptcy court to refuse to give you a discharge. This is not about just not discharging a particular debt. This is basically saying that you go through the whole process of going through bankruptcy and it turns out that it's all going to be dismissed and you can't file bankruptcy again for a certain period of time. It's a pretty drastic punishment for doing something that you thought was kind of making sense. Again, transferring property to somebody else. And even worse, if you try to undo it. So let's say you quitclaim your house to your brother, and then you find out to your horror that you can't do that, and you say to your brother, transfer it back to me, and he executes a quitclaim deed back to you. Doesn't matter. The fact that you did the act, you transfer the property out of your name, makes it a fraudulent transfer. You can't really undo a fraudulent transfer. And again, there's some time limits and things like that where you could eventually get past all this type of stuff. You still have to reveal it. But the point is it's going to, at a minimum, it's going to delay how long you have to wait before you can file bankruptcy and get a discharge, or it may end up having your discharge prevented entirely. So don't transfer property is the big picture here. Second thing is moving money, and this is kind of related to the fraudulent transfer, moving money out of a joint bank account into, let's say you're married and you've got a joint bank account with your spouse, taking all the money out of that joint bank account and putting it in your spouse's name. That's also a fraudulent transfer. And the other thing is, if you are, let's say you've got a debt to somebody, it could be a relative or it could be a third party, and you decide you're going to go and you want that person to get paid. You're filing bankruptcy. I want my brother to get paid. I bought something from him. I want to pay him. And you go ahead and pay an insider, a relative, close friend, or even a third party for that matter, that's not a relative, and you pay that person, but you don't pay other creditors at the same time when you're essentially insolvent. That's called a preferential transfer. That's a problem, because what happens then is the trustee will go to your brother and say, I'll have that money back. It's within a year, I want that money back. If it's to a third party, it could be a 3-month look back. But I've had situations where people, and this will affect small businesses, they have, let's say they have a vendor that they work with who built a porch for them. Let's say they didn't pay for that porch for 1.5 years, and then they're getting ready to file bankruptcy, and they say, I feel bad. I didn't pay Henry. He was a really good worker. I'm going to go ahead and pay him now. The problem there is this is a debt that had not been paid, so it was called an antecedent debt, an old debt. You paid it sort of not in the normal course of business, and now it's a preferential transfer. The trustees are going to go to Henry and say, even though you did the work, even though you're really doing anything wrong here, I'm taking that money back. And that's a pretty brutal thing to have happen to people. And obviously if it's a relative or a friend, it's going to make for a really uncomfortable Thanksgiving dinner. So you just got to be real careful about making payments, either transferring money outright or making payments to people for old debts because you want to get them paid before you file. This is, again, we're talking to a bankruptcy lawyer who will really help you. Third thing I see, I call it throwing good money after bad. And the other way to look at this is called the sunk cost fallacy. And that is that, if you have, let's say you have a vehicle that you just put new tires on the vehicle. Let's say you just got a new transmission made. You put a lot of money into this vehicle. Or even worse, you have a timeshare and you've been paying on that timeshare for 5, 6, 10 years, never been to it, but you've been paying on it for all this time. And comes time for bankruptcy and your lawyer says, you know what, let's just get rid of this. You can't afford it, you're not using it, it's not a good deal. You're like, I put all this money into it, I don't want to do that. That's the sunk cost fallacy. You're throwing good money after bad. Don't want to do that. When you go into a bankruptcy, everything needs to be on the table. And if it doesn't make sense, it doesn't make sense. Whether you have put a bunch of money into it, whether you've just bought new tires for that car, just paid for a new transmission, a whole service, new timing belts, all that stuff, it doesn't matter. You got to get rid of the debt. But people are resistant to doing that because they just put money into it. They don't want to throw, they don't want to lose what they put into it, not realizing the big picture says you got to get rid of this debt entirely, and you can use bankruptcy to do that. So don't fall victim to the sunk cost fallacy. Along those lines, number 4, I call it, again, throwing good money after bad, and that would be, you're filing bankruptcy and you've got a credit card debt that you've been paying on, and while you're saving up the money to pay the lawyer for bankruptcy, you keep paying on the credit card debt. Don't do that. If you're going to file bankruptcy and you've got a debt, setting aside the preferential transfer, all that kind of stuff, if you've decided you're filing bankruptcy, stop paying everybody. Again, with your lawyer's advice, but there's no reason to pay money, if you've decided to file bankruptcy for a debt that's going to be discharged. You're going to be cash strapped as it is after bankruptcy. You're not going to have access to credit, and you want to limit your expenditures so you've got as much money as you possibly can. You can have a certain amount of money and still file bankruptcy. It's called an exemption, where you're allowed to keep a certain amount of cash under Georgia law, even after filing bankruptcy. So you want to max that out. No reason to pay a creditor, and a lot of times, of course, the creditors call you and they try to make you feel guilty. You're a bad person if you don't pay this credit card debt. Nonsense. Once you make the decision to file bankruptcy, unless your lawyer tells you otherwise, unless it's a secure debt like a house or a car that you want to keep, stop paying it. So you can save that money, keep it for yourself. Again, bankruptcy is about survival. You got to do what's best for you, and the guilt that the creditors try to put on you, I say is bogus, because realize the creditor lobby are the people that made this bankruptcy law that we've got, put it in force. They lobbied to get it enforced, and it benefits them much, much more than your not paying them is going to hurt them. So I have no sympathy for most of these consumer lenders. It's pretty much garbage there. All right, number 5. And this I see sometimes very, very frustrating. Somebody has a bunch of debt and they enter into a consolidation loan where they want to combine all their debts together. So instead of having 5 payments, they have 1 payment, and it reduces the monthly outflow. It sounds great. The problem is the consolidation loan is a new loan, and bankruptcy doesn't work real well when you've got new debt. You can make an argument if you're a lender, this is a new debt. This person filed bankruptcy. It was bad faith, even though the debts were consolidated from debts that have been 5, 10 years old. It doesn't matter. As far as we're concerned, it's a new debt. So be really wary about consolidation loans, things like that, before filing bankruptcy. Again, this is where a lawyer can help you. And again, I'll say it again, if you see bankruptcy on the horizon, even if it's 6 months, a year down the road, pick up the phone, call a bankruptcy attorney, call us and talk to us about your situation. Talk about those things you're thinking about doing. Use bankruptcy lawyers as a resource before you file bankruptcy, because again, we'll be able to tell you this is a bad idea, this is a good idea, this is what you want to do, this is what you don't want to do. This is how you protect yourself. This is how you come out of bankruptcy with as much cash as possible. Do that. You can make a difficult process, the bankruptcy process is always difficult, you can make it more pleasant and more effective, most importantly, than it otherwise would be. by talking to your bankruptcy lawyer early. Hope I can be that person. Reach out to me, 770-393-4985, or online at atlanta-bankruptcy-attorney.com. This is Jonathan Ginsburg wishing you the best. Thanks a lot.